in the Constitution, Jefferson becomes the first patent examiner. So be careful what you agree to in the federal government, because once you agree to it, you might end up doing it. And then with our Patent Trial and Appeal Board, that's a big number, 394. Not all of them are judges. That's judges and support staff. Only about 270 of them are actual judges. And then the 71 Trademark Trial and Appeal Board judges, that's also support staff. So it's not all judges. We probably should fix that slide so that it reads accurately. Anyway, the Patent Trial and Appeal Board they perform two essential functions for the office. The first one is when you reach an impasse with an examiner, a Patent Trial and Appeal Board judge will go ahead and decide that case. He'll decide whether you were right or whether the examiner was right or whether you were both right in some instances. And so that's an essential function that they perform. But the other essential function that they perform is to take a second look at the patent after it's been issued to determine whether it should have been issued in the first place. So those are the two essential functions of the Patent Trial and Appeal Board. Trademark Trial and Appeal Board does things similar for trademark side of the house, as you might imagine.
An interesting observation is the trademark approval rate looks lower than the patent approval rate, which, trademarks are easier than...
Let me get there. Well, but people make really easy and common mistakes, and we're going to talk about some of those, right? So this number, right, the patents, 650,000 patent applications filed in FY16, and then only 334,000 patents were issued. Now, that is not a one-to-one correspondence, though, right? Because how long does it take to get to office action? 16, 17, 18, depending on your months, depending on your technology center. So that's not a one-to-one correspondence. However, on the trademark side, that kind of is, because you can get through the entire trademark process in anywhere from 6 to 9 months, depending on where your application is. So yeah, they received 530,000 trademark applications and only issued 227,000. And a lot of those denials come because people didn't do searching, because people didn't claim the goods and services the correct way. And so that's where those denials and abandonments come from. So anyway, that's us. In 2011, the America Invents Act did lots of different things. One of the things that it did, though, was it established our regional offices around the country. So for 220 or so years of our history, we were in Washington, D.C., or within viewing distance of Washington, D.C., and if you wanted to work with us or for us, you went to Washington, D.C. That changed in 2012 when Detroit opened up. So the Midwest regional office opened up in Detroit in 2012. They just celebrated their 5-year anniversary. Rocky Mountain office in Denver was next. We opened up in 2014, so we are now 3 years old. I always like to say that. I'm going to have to get more hands, hopefully. And then the Texas regional office and the San Jose, or the Silicon Valley regional office in San Jose, both opened up in October and November of 2015. So it has been... We have radically changed how the patent office operates in the last 5 years, and I think we're still kind of reeling from all of that.
All the branches about the same size, or are they different?
All of the regional offices are about the same size. Well, it was designed to start out that way. What we've ended up finding is that some offices have their examiner's hotel, where they go out of the office into, working from home or working, in another state. Some offices have had that happen almost exactly on the dot, and other offices, people like Denver, people have stuck around. So, for example, in Detroit, they were able to hire a new class of examiners pretty much right after their 2-year anniversary, because they had a number of people that just became eligible to go telework, and then they hired a new class. We have not, because apparently people like coming into our office. I keep telling them, I love you, now leave. Get out. I want to hire a new class. So we actually now, at 3.5 years, are finally able and ready to hire a new class of examiners. So Detroit has grown a little bit faster than any of the other offices. They've been open longer. They've hired about 143 examiners. Denver's only hired 90 new. And then we'll have another class that's coming on board, and that number will go up a little bit. More interestingly, though, is the number of people who have come into the region based on, a regional office being in that region. So for our 9 states, in 2014, before the office opened, there were, I think, like 80 total across all of the states. I think it was 88, and now there's over 100 or 200 across all of the states. We've increased the U.S. employee footprint by over 700% between the hotelers that have moved in and the office. Yes, sir. Right now, we have about 55 that come into the office on a regular basis. We'll add another class of 25, and then we're also accepting transfers of 10. So people who are already working for the office but who want to move to Denver have that ability. They had to get on a wait list. And so we'll have like 35 newbies. I'm really excited for the new blood. It'll be fun. Silicon Valley is actually hiring another class because they've had, even though they're just at their 2-year mark, they're hiring another class. Texas probably won't be ready to hire another class for at least another year. So that's kind of where we are. And those are just some of the differences in the offices. And, I think we designed them to be all the same in the beginning, and we're finding that there are individual differences and individual cultural differences that I think are going to dictate some changes in the future. But right now, we're all the same. We always like to talk about why IP matters, and this is why, this big number up here. So for the IP-intensive industries in 2014, there was a value add of about $6.6 trillion to the U.S. economy. That's real money. There's about 28 million IP-intensive jobs in 2014. But the thing that is interesting is this number right here. So for people who work in IP-intensive industries vis-a-vis people who don't, people who work in the IP-intensive industries experience a 46% higher average weekly wage than those who don't. So, and all of this was taken from the USPTO's 2014 and 2016 IP in the U.S. economy reports. So you can go look up those things and you can figure out this one. Someone asked me the one day, they're like, Molly, name all 28 of the industries. I'm like, no, go read the report. Now you have homework. Because I read the report, but I read it with a glass of wine at night. So, that's how it works. IP in Colorado, this is actually from the Global Intellectual Property Commerce Group. Which is part of the U.S. Chamber of Commerce. They actually rank all of the states according to, where they are in the IP world. Colorado ranks relatively highly. This is from their report that's called IP Creates Jobs, and in Colorado there are about 951,000 IP-related jobs. So they count like scientists and engineers and people whose job it is actually to create patents or intellectual property. We had 3,755 trademarks registered in the state, and about 3,000 utility patents registered in the state, and these are all for 2015. So we do not have our FY 2017 numbers. It just ended on September 30th of this year, so we will have those numbers. Those numbers will be coming out soon. This is our cycle of innovation. I always like to think of it as a spoken wheel because you're doing a whole bunch of things all at the same time. And the one thing that's actually missing in here, but I think it is enveloped in this research and development, is the searching that Roger was talking about. And one of my favorite things to do when I was a patent attorney was that whiteboard analysis where my engineers would come to me and they would say, okay, Molly, we want to design something in this space. Go find the patents that are out there, and then we would spend a couple days mapping out the patents and finding what we called the white space, which was where we thought we could get some significant scope to our patent coverage. And it was a really interesting and neat way to invent. Number one, because I got to do it with them, so that was very cool. Most of the time, engineers, kind of give the hand to the lawyers. But they involved me, and it was so much fun, and we really did. I think, some of the products we created that way were some of the best ones. They sold really well because they met that market that wasn't out there. And then the other caveat that I should give you is just because it's not on Amazon, just because it's not at Target, just because it's not at Walmart or Home Depot, does not mean that it hasn't been patented in the past. Forbes in 2014 had cited a report in one of their articles that said out of the 2.1 million active patents, about 95% of them never see any commercial activity. You know, they're not licensed. So just because you can't find it in the marketplace doesn't mean it doesn't exist in the patent world, and that's why the databases that Roger was talking about, that you can only access at a Patent and Trademark Resource Center or at the Denver office or any of the other regional offices or headquarters. That's why they're so important. Because Google natural language search or any of the other searches that you can do online is really important. But I will tell you that to people like Roger and Jeremy and I, a screw is not a screw, that's a fastener. And so we use language that you guys might not. And if you only search what you use, and you don't have kind of that expertise to tell you, no, you know, you need to call a screw a fastener, or you need to call, you know, an air conditioner, an air mover too, and, you know, those kinds of things, you really might miss some of the key references that you need to make sure that you don't try and patent something that already exists, because then that's a lot of wasted time and money. And I always tell people who are a proponent of the fail fast entrepreneurial methodology, if you come and search the patent database and you find that somebody has patented your idea before you, then you have already failed. You have failed fast with a minimum investment, and you are failing forward. Because now you have to make sure that you have a different business model. So you can license the patent from the other person, because clearly, since it, and I'm guessing, wasn't on Amazon, it wasn't on Walmart, it wasn't at Target, they didn't get it commercialized, perhaps you can license it from them. Or you can go back to the drawing board and start inventing again, and you've done all of that before investors have made you or have given you a check. So please use us. We have search terminals in the regional office. I will warn you ahead of time, we are in a federal space, so you have to go through Federal Protective Services, so don't bring anything to my offices that you wouldn't take on an airplane. This is a special warning to my dad, who has a pen that is shaped like a rifle bullet that he insists upon bringing to my office every time, and then I get a visit from Federal Protective Services that yell at me about my dad. It's awesome. So anyway, this is definitely like some of all of the things that you're going to be doing in that. One of the other things that we did, and this is something that I really appreciated about our former director, Michelle Lee, she was very interested in quantifying. So people who are patent attorneys can tell you anecdotal story after anecdotal story about how important intellectual property is to a company. Those are anecdotal stories. Taken all together, they're great, but there wasn't anybody who was really looking at numbers and quantifying those things until this study. It's called The Bright Side of Patents. And we asked 2 New York University professors and a Harvard professor to go ahead and look at these things for us and to determine and to answer the question once and for all, is a patent important to a startup or an entrepreneur? So they studied 45,000 applications from 2009 to 2013 across all technologies. So this wasn't just software, it wasn't just biotech, it was across all technologies. And they determined that the answer to that was yes, it matters whether or not a startup has a patent, and it matters to success. We'll talk about that in a minute. The interesting part was, and the takeaway for us was, it matters when. So for a startup or an entrepreneur to get their first issued patent after the first 5 years of their existence didn't make that much of a difference. The place where we could really make a difference, the U.S. Patent and Trademark Office could make a difference for entrepreneurs is in that first 5 years, and that's if they get an issued patent. And then these are some of the things that they were able to get from that first patent grant. So it does increase the likelihood of additional patents. That one is a little bit self-serving, I think. You know, that was kind of the, hey, thanks for commissioning the study, USPTO. But The other thing that's there is that it increases the quality of the patents, and one measure of quality is how many other people cite to your patents, right? So if you have an early mover technology, there are going to be a number of people who are going to be citing to your patent. So this actually increased the number of citation to those first patent grants by over 26%. It also facilitates access to capital and rewards investors. We're going to talk about that in the next 2 slides. So in facilitating access to funding, what they found was that the companies who had a first patent grant in the first 5 years ended up with a 53% increase in probability of VC funding over those that had no probability of VC funding whatsoever, right? So, and no patents. So that was one of those things. There was a small increase in the likelihood of getting a seed round of funding. I think that was because most of the people who were in that patent process used their seed round for actually paying for their patent attorneys. And then this one, the 47% increase in the probability of the second round of funding was also, kind of a big deal. And these effects were greatest for people who were inexperienced entrepreneurs or who were in states or regions that don't really have ready access to VC capital. So technically my region. So we thought that was interesting. Again, it rewards investors. Those that had that first patent grant in the first 5 years had a 153% increase in probability of an initial public offering, or when you looked at everything, whether they got acquired or an IPO, it was an 84% increase in the probability. It's a really interesting study. It's a little wonky for those of you but I like those studies, so that's why. But anyway, it's called The Bright Side of Patents. You can find it on our website, www.uspto.gov. For those of you who don't know, it's there. All right. The other interesting thing about patents and intellectual property is that it helps give value upon dissolution of the company. I know that's not anything that any of you want to think about, but at the end of the day, a patent or a trademark or a copyright or a trade secret are assets of the corporation. They can return money to your investors, and the most recent example is Jawbone. So just this summer, Jawbone declared bankruptcy, and IAM magazine said that they were going to be returning in between $25 and $40 million back to their investors upon the sale of their patent portfolio. So it can return real money to the people who had the faith to invest in you, even if things go belly up. Okay, we always say, you guys aren't asking enough questions. We always say that intellectual property strategy is a business strategy. It is something that you need to consider along with your business plans, along with your procurement plans, along with how you're going to manufacture. This is definitely something that you need to consider. And when I say intellectual property, I mean all forms of intellectual property. I mean patents, trademarks, copyrights, trade secrets, right? And the way that I want you to think about them, and this is a great analogy for where we live. If you've ever driven around Colorado, you know those the fencing, the barbed wire fences. All right. So think of each form of intellectual property, patents, copyrights, trademarks, trade secrets, as one of those fence posts, right? So in order to protect a piece of land or your garden or your ranch, you're going to put fence posts at regular intervals, right? And you're going to look and you're going to see whether or not this fence post is working for you, or whether you need to maybe move that around and use a different wood or perhaps a different tool. So you want your IP strategy to be nimble, and you want it to change over the course of time. And then you need to think about all the agreements that you enter into, both the outgoing and the incoming agreements, as the barbed wire between those fence posts. Because it isn't enough for you to protect your intellectual property if you give it all away in your agreements. So you need to watch what you're doing, not just from here's how I'm going to protect it with the fence posts, but here's how I'm going to enhance that protection and keep people out of the space that I want to claim for my own. So that's, I hope, a decent visual for you guys. That'll Just think of them as fence posts and then watch your agreements, your non-disclosure agreements, your employee agreements, your contractor agreements, your procurement agreements, your supply chain agreements, your manufacturing agreements. Facebook. Any license agreement that you sign, you need to read and you need to understand whether or not you're actually giving something away with that license agreement. So, intellectual property is attractive to investors and buyers. I can tell you from my own experience, having done the intellectual property due diligence for all of the companies that I worked for, it could make a difference in the purchase price of sometimes 20% one way or the other. If your IP strategy hung together, and I can tell you 2 stories about that. And then we'll also talk about this. Oh, wait, no. There. That canary in the coal mine statement. So over the years, when I would work with the M&A guys, none of them were patent attorneys, so they would just call us in and say, hey, look at this target, see if they're okay. And over the years, they would actually give me a call before they issued the letter of intent after we had a couple of things happen. And then they'd just say, Mal, go do a quick and dirty search and see, what intellectual property this company owns and, does it make sense and see where we can go with that. Because we had one situation in the same year, 2 companies, exact same deal price. The first company had their intellectual property story together. Everything hung together. They had a really good story. Even though they had a bad fact in the portfolio, they had sold off part of their early patent portfolio, which did not make the company I was working for happy because they like to own everything. But they had a story about it, and we understood. And they had made a pivot, both with their technology and with their portfolio. And they said, well, why should we keep paying for things that we're not using? So it really made sense, right? All the way down the line, that company had it going on. I think it was 6 weeks from LOI to completion of purchase and another 24 weeks beyond that until they were fully integrated into the company. Pretty good, right? And a lot of, okay. Same year, same deal price, company tells me we don't have any patents. And I say, well, what about this German patent that you have? And they had no idea. They had no centralized mechanism of monitoring their intellectual property, and that turned out to be how they ran the entire business. So every single country, every single place that they had a presence, they had their own intellectual property, they had their own procurement, they had their own supply chain. They had 3 years later, that company still wasn't integrated. Same deal price, exact same deal price. One that gets integrated in basically 6 months, another that doesn't get integrated for 3 years. And so we always used to say, if your IP strategy hung together and we had mechanisms for detecting when that happened, we knew that the deal was going to go either easy or hard. One of the ways. It never actually stopped the company that I was working for necessarily from buying, but we knew what we were getting into at the very beginning. So intellectual property can be that canary in the coal mine. And one of the reasons that I think that is, and this is totally just me, but I really think that's because if you can do what it takes to look at your intellectual property strategy and take that step back from the day-to-day of your business to think about your company 5 years from now, that you can do that in every instance. And then you can do that for HR, you can do that for your contracts, you can do that for your limitations of liability or your, any of the other things that end up being really big deals when someone's looking to acquire you as a company. It is, as we talked about, a property right that can add value to your company. It is global, so you can get a patent or a trademark or intellectual property in any country, but it is territorial. So you cannot enforce a Canadian patent in the United States. You would have to enforce it in Canada. You can't enforce a US patent in Mexico or in Canada. You have to enforce it in the United States. So it's global, but territorial. And, but also, right, with being global, query whether or not you want to be global. And I hate to pick on Syria right now because it seems like kicking a dog when it's down. But Query whether or not you want to get a patent in Syria. I don't think there are any judges to enforce it in Syria anymore, so is that patent actually going to be worth anything down the line? I'm not certain anybody's selling anything into Syria either because they're on the banned country list. So, right, like you really, when you're thinking about where you want to protect your intellectual property, you want to be thinking about your markets, you want to be thinking about where you're going to be going and where you think you can make money and where you can enforce. Right? And that analysis was different for some countries even 3 years ago, maybe even 5 years ago. That analysis was very different for some countries. So that's definitely something you want to educate yourself on and learn about. We always say that developing an IP strategy comes with assessing your company's IP assets and prioritizing them. You can use an intellectual property attorney to come in and do like an intellectual property audit, or we developed a kind of like what Game of Thrones character quiz are you with the National Institute of Standards and Technology that's just up the road here in Boulder. But it basically walks you through your company and helps you see the intellectual property that might be associated with that. And it will point out the things that perhaps might not be obvious. So we're gonna go back to our little Diet Coke prop, this little bottle. The best part about this bottle is it came with bourbon, so, and Diet Coke, but there's nothing left in that. So, okay, what forms of intellectual property, and Jeremy, you are prohibited from answering this. You too. Roger. What forms of intellectual property are associated with this bottle? Design patent, right? Yep. Definitely trademark. There's the little circle R symbol, right? What else?
The contents on the inside would be a trade secret.
Exactly, except that there's nothing inside anymore, tragically, right? What else? Uh-huh. Yep. So the interesting part about it is there's actually a trademark on the bottle itself. So it was a design patent. They started it out as a design patent. Once it gained enough notoriety and people associated this shape with Coca-Cola bottles, they filed for a trademark application and they got it. It's probably one of the only ways to extend a patent term that I can think of, because patent terms, right, they're for a term. Unless you have a patent term adjustment that gets granted by the U.S. Patent and Trademark Office, you have 20 years from the date of filing, 15 years from the date of filing for a design patent. However, they were able to show that this has, that the people associated this shape with Coca-Cola, that it had no utilitarian features connected with just the shape, and they were able to get a trademark on it. And now that right is, this is a trademark for as long as they're using it in commerce. So,
How is there a utility patent
on the filling and the capping, not on the bottle itself.
That's the process, I got you.
Yeah, exactly. So, okay, so that's just a little quiz, but one of the things, there's also copyrights associated with the way the thing is laid out, and probably some of the information that's on the back. So, right, we missed you can look at something that simple and not realize how much intellectual property goes into it. So that's why I really like the quiz that we have. It's called the IP Awareness Assessment. IP Awareness Assessment. It's on our website, www.uspto.gov. You're going to hear me say that a lot tonight. Know your competition, right? Because that's actually going to inform what form of intellectual property you want. What's the pace of innovation and opportunities for growth? You may not want to get a utility patent on an industry that moves every month, right? Or where you're coming up with, like in fashion, you're coming up with new designs every single spring, fall, winter, summer, right? Maybe a patent isn't the way that you want to go, although maybe it is. But you want to take a look at that and factor that in. Determine the best way to protect your intellectual property. Develop your plan, set your goals, and implement, and then get help. And the one thing that we at the U.S. Patent and Trademark Office want you to think about is to try and get help from us. We are there to provide you with information and options, and we'll talk a little bit more about some of the programs that we've put in place recently. One thing you should know with the America Invents Act, you heard me say it, that it changed a lot of different things. The biggest one is that the U.S. went from a first to invent to a first to file system. Basically, it means he or she who wins the race to the patent office is deemed the presumptive owner. We've had people try some of the proceedings to say, no, 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 I invented first. Exactly 0 of them have succeeded thus far, so it really is the race. So get to the patent office first. Provisional applications are your friends in that sense, and we'll talk a little bit about that. Again, for a lot of countries around the world, any public disclosure, any sale before you have a patent application on file will mean that you will lose your international patent filing rights. So please be very aware of that. You do have a grace period still in the United States of a year where your own words can't be used against you. So you have a year from the date that you publicly disclose or sell to file a patent application, whether that's a provisional application or a non-provisional application. That's fine, but you have that year. If you've disclosed or sold before you file a patent application for a lot of the rest of the world, you're done. And so then the interesting thing is how intellectual property law keeps pace with technology and how people are doing things. And query, this is a place where I think there's going to be a lot of litigation about who owns, what it means to conceive of an invention, and when it is actually on sale is these crowdfunding campaigns. And so unless you want your name associated with those cases, and perhaps you do, I'm not saying there's anything wrong with that, although it's a really expensive way to go. The best way to avoid that is to be very conservative, and before you put your invention on Kickstarter, make sure you have a patent application on file with respect to that. Okay, so that's it. Yeah.
So I know previously they said get an inventor's notebook, have like a witness sign and all that stuff.
Uh-huh.
Does that matter anymore?
Not really.
Okay.
Not really. I always like to tell people to do it because if you have a brain that's like mine, like the thought comes and then it's gone. Right? So, thank you, son. My son is testifying as to the fact that his mother can't hold that in her head. But right, so like I always like to have but it's not necessary, right, to have somebody else witness it. Because query whether or not it will actually do you any good down the road in terms of being the best thing to do, right? Get it written up into a provisional patent application and get it on file. So, okay. This is a really fun slide. We still haven't changed it the way that I like to do it. So we're going to start in the middle with trade secrets because trade secrets are the least cost to obtain. There is no registry for trade secrets, right? Because, and this, it's in the name, right? A trade secret has to remain secret. You can't tell it to anybody. You have to protect it. You have to keep it from people. And that takes a whole bunch of different forms. You know, that might take, you know, if it's a manufacturing process, it might take throwing a sheet over some of the process whenever you have public visitors. It might take you signing confidentiality agreements for anybody who walks into your plant. If it's a piece of software, it might take putting some of that source code in a really, really cryptographically secure place. And, you know, delineating your workforce and dividing them up as to who really needs to know about whatever is in that source code, right? So you need to be thinking about that. And these slides will be available to you guys because I work for the government, so it's all free. Until you want to use our services, and then you have to pay us fees. But anyway, a trade secret has to have commercial value. It has to give you an edge over your competitors. It can be anything, though. It can be, you know, but it has to be related to the business. The classic trade secrets were customer databases. I think LinkedIn destroyed a lot of that because you can just look at who somebody knows, and most people link their customers to themselves on LinkedIn. But it might be, you know, a manufacturing process or a formula or, you know, the algorithm that forms the basis of the software functionality, right? Like Google.
Yeah,
And
one of the beauties of trade secret is no subject matter limitation.
right. There's no subject matter limitation when it comes to trade secrets. The only thing that matters is whether or not you can protect it. So if you manufacture widgets and anybody who gets your widget and buys it can reverse engineer it in a heartbeat, trade secret might not be appropriate for you. However, if you have really complicated software that you can lock down so that people can't get access to the source code, perhaps trade secret is the way that you want to go. All depends on what you're selling, what you want to build your business around, and how much you think you can protect it. So with National Cybersecurity Center, we want to do a talk called Can You Keep a Trade Secret Secret? In the world of hacking, it's pretty much a question of when, not if you're going to get hacked. And so what measures have you taken against hackers to keep your trade secret secret? All right. So rights of independent creators, I want to explain that line. Go back. This bottom line right here. So an independent creator is somebody who's kind of in parallel to you but doesn't have access to what you're doing, right? So it's somebody who might be on the same path as you, and can they, if they come up with exactly what you come up with, can they still own what they've come up with vis-a-vis what you've come up with? And in the world of trade secrets, unless you can show that they copied from you, they still have the ability to do that. Right, okay. Does that make sense to everybody? So with respect to copyrights and trademarks, unless there's copying or misappropriation, they have the ability to create on their own. With respect to patents, design patents, utility patents, trademarks, and plant patents, they don't have that. If it infringes, it infringes. It doesn't matter how they came up with it. Does that make sense to everybody? Yes, sir.
The copyright part doesn't make sense to me. Can you explain that?
Okay, we'll get there. Okay, so trade secrets stay secret until they're no longer secret, and then you can't put that barn door, can't shut that barn door. All right, copyrights, next least expensive to obtain, but copyright protects the expression of the idea, not the idea itself. So for example, if you have a software program that performs functions A, B, C, and D, and you write it in Java, and somebody else writes that same program in C++, you're done if all you have is a copyright. Because copyright protects the expression of the idea, not the underlying idea itself. If you want to protect the idea or the functionality, you're in patent world, okay? And that's why the right of an independent creator, you and I can stand in front, we can stand in the exact same place in Estes Park and take the exact same picture of one of the stores that has a moose in front of it, or an elk, during bugling season, right? And you and I both own the pictures that we took. That's what it means by full rights. I didn't copy from you. I didn't take your work and do something else with it. I was there, I was standing right next to you, we took a picture of the exact same thing. We each own a copyright in the picture that we took, even if they look perfectly similar. So that's kind of how you have to think about copyright. Most people think about copyright in the form of art, music, sculpture, portraits, photographs, books, those kinds of things, movies. All of that is copyrights. It has to be original, and there has to be an element of originality to it. So for example, in that photograph example that I just used, we both had the idea to get that angle, that lighting, and to make sure we captured the elk in the photo, right? That's kind of the originality aspect of that. The interesting one is authorship. That never actually used to be a thing until I think it was the orangutan took a selfie with someone's camera and they took the selfie, and it was a really great selfie. But it's an orangutan, and they can't own it. The Ninth Circuit, in its wisdom, actually ruled that an orangutan can't own the copyright, which I actually appreciated, because I thought that was the right outcome. But they couldn't decide whether I think PETA got involved too. So there were like 3 people who were contesting the ownership of that particular photo. And basically what the Ninth Circuit said was nobody gets to make any money off this photo. It's just out there. Because the orangutan took it of himself. So authorship means now authored by a human being. I love it. It's kind of cool. And that's new in 2017. And then fixation in a tangible medium, all that means is for like a computer program, the minute you hit save, for the photograph, as soon as you click it and it's fixed. If you're a sculptor, when you finally sign your work or sell it, that's when it's fixed in a tangible medium. It just means when you're done, right? And then copyrights actually exist almost as soon as you fix it in a tangible medium because of the Berne Convention. So the Berne Convention is a treaty that pretty much every country in the world belongs to. And so your copyright exists. If you want to enforce it, you have to have a copyright registration in wherever you want to enforce. Because remember, we talked about the fact that IP is global, but it's territorial. So you have to have the copyright registration in the United States. You want to have your copyright registration before somebody infringes, or you can file it soon thereafter. But if you file it after somebody is already infringing you, you're losing damages. So you want to file it before. And typically that takes the look of, I know, I get a lot of hits on my website for this photograph. You might want to think about making sure that you have a copyright registration for that photograph. Trademarks. Please think about trademarks as a source indicator. Do not think about them as, you can think about them as a brand, right? But at the end of the day, your trademark should be the thing that makes people know that they're getting their goods or services from you, right? Love it or hate it, you know what you're getting when you're walking into a McDonald's or a Starbucks. And why? Because of the power of their mark and because of the experiences that you've had. So I always like to call trademarks the gateway drugs to intellectual property because they are something that we intuitively understand, we get it. We eat them, we drive them, we wear them, we sleep on them. We are surrounded by trademarks every single day. And so that is one of the things that you want to think about it, though, as that source indicator. Thank you, dear. You must use a trademark in commerce, and you must continue using a trademark in interstate commerce in order to be eligible for a federal trademark registration. You can use it until it's abandoned. You do, however, for a federal trademark registration, have to tell us that you're still using it in commerce, or you could be subject to a cancellation proceeding. We make you do that in between your 5th and 6th year of registration, and then at your 10th year, and then every 10 years thereafter. So as long as you're still using the mark in commerce, you can continue using it in perpetuity, basically, as long as it's being used and you can show that it's being used. Let's talk a little bit about selecting a trademark in case that is something that you haven't gotten to yet. You want to think of it as a spectrum of marks. We're going to start down, and I always use Mexican food for this, and I need new, because then I get hungry. So on the generic side of things, as we intellectual property attorneys refer to it, the burrito place is probably a generic mark, right? If it's a restaurant that's serving burritos, the burrito place, not a lot of guesswork there, right? You kind of know what you're getting as soon as you walk into it. All right, so that's what a generic mark is. There's really nothing to it. There's no pizzazz. There's no uniqueness so that you would know that one burrito place was different from another. That's a generic mark. Next up is descriptive. So Benny's Burritos, right? Presumably at one point they were burritos made by a guy or gal named Benny. Still not a lot of mystery about what you're going to get there other than who Benny might have been, but not really, you're getting burritos when you walk in there. So that's probably a descriptive mark. Next up from that, and we call, for the U.S. Patent and Trademark Office, generic and descriptive marks are inherently unprotectable. So if you have a generic mark or you have a descriptive mark, and description is also a key factor in geography. So if your mark gets rejected as geographically descriptive because you called it Colorado burritos, again, you're not going to be able to get that mark through the U.S. Patent and Trademark Office. The next up, though, that is protectable is suggestive. And this one might be Chipotle. right? Because Chipotle is a pepper that's sometimes used in Mexican food, but it could be something else. You don't know that you're going to get a burrito when you go into Chipotle, although most of us do. You know, and if you believe the newspapers, you will also get salmonella. So, right, that's something suggestive. Arbitrary or fanciful, which is where you want to be when you're selecting your mark, is Qdoba. Made up name, doesn't mean anything in Spanish or English, quite frankly, right? And someone told me once that it means something in one of the Native American languages, but they can't prove it, so I don't believe it anymore. But right, like it really doesn't mean anything. And so it's arbitrary or fanciful when it's applied to the services of restaurants serving Mexican food, fast Mexican food. I mean, now it's synonymous with fast Mexican food, but when they started, that mark was arbitrary or fanciful. And then they've just built that brand enough that you now associate it with fast Mexican food. Also be selective about when you're selecting your mark, and this is where I encourage people to dream big about their intellectual property and where they might take their company. So in the 70s, there was a little company that thought that they would put the name of a fruit on a computer. And there was another little company that was owned by a very, very tiny band called the Beatles, called Apple Publishing. And Apple Publishing had an issue with Apple Computers registering the name Apple for computers. So Apple Computer agreed with Apple Publishing that they wouldn't get into the music industry. How did that work out for them? Yeah, right? Like, so dream big, right? And make sure by doing trademark searching and everything else that you can do, you know, there's a number of ways that either an intellectual property attorney can help you or that you can come into the U.S. Patent and Trademark offices and search our databases and we'll help you look for, you know, and do the search. That part of it, dream big there. Don't limit yourself. Don't choose a mark that might be arbitrary or fanciful for where your business is today, but maybe not where your business might be in 30 years. So there's a lot of ways you can make up names and then just do the marketing and the publishing and the other things that are necessary with, you know, creating that brand buzz. All right, we talked about that. Let's talk about the 3 types of patents. So there are 3 types of patents: plant, design, and utility. Of the utility patents have 2 types of applications, provisional and non-provisional. There are no provisional patents with respect to plants. There are no provisional patents with respect to design patents. There are only design patents and plant patents. With utility, there's provisional applications and non-provisional applications. Plant patents, of course, protect asexually reproducing plants, or as we like to say, the plants that don't have any fun. Design patents protect the ornamental features of a device, but they have to be ornamental. So you find design patents in the world of jewelry, in the world of household appliances, in the world of, well, actually in the world of phones. Right. So I think the most famous design patent right now is the rounded corners of your iPhone. That's the subject of many of the Apple versus Samsung lawsuits around the world. So that's what a design patent is. Interestingly enough, the Rocky Mountain office has a design supervisory patent examiner in its office. And I'm hoping to get a design patent examiner soon. So the Rocky Mountain Regional Office is the only regional office that has a patent examiner in every technology center. We do not have any plant patent examiners, thank God, because they would be like overloaded with questions in this state. And so we don't have any of them, and I'm really not wanting any. And then, but we do have a design supervisory patent examiner, and then we also have utility patent examiners in a lot of different areas, some that you might not expect. We have actually 2 in the guns and ammo. We have a couple in the solar cell, so it's very, very, very cool to see what goes on in the office and to see what people are talking about. It's kind of fun. But also, there is no requirement to submit a prototype to the U.S. Patent and Trademark Office, and especially if you're in the guns and ammo area, please don't send it to a federal government building. I can't tell you the amount of paperwork that makes me fill out. Don't give me paperwork. I don't like it. So, talked about design patents, utility patents, and we went through this very deliberately where we started in the middle, because remember I said trade secrets were the lowest cost to obtain. So we've just gone steadily up in price, by the way. So utility patents, those are the things that protect the functionality of your invention or your design. So, those are the things that you see the most. That's definitely the bread and butter of the U.S. Patent and Trademark Office. So that's all of that. The requirements for a utility patent are usefulness, novelty, and non-obviousness. Usefulness is the subject matter area, but anybody who tells you that software patents are dead has a different agenda. They're not dead, they're just more difficult to get. But that's where, patentable subject matter comes in terms of usefulness. So there are some things that shouldn't be patented, and we can talk about that a little bit later. Novelty means no one person has done it before you. And non-obviousness basically means, given the entire state of the technical art of the world, is your invention an advancement over that? So, as you might guess, non-obviousness is the most difficult hurdle for most patent applicants to overcome. We talked about, utility patents protect from making, selling, offering for sale, having made, and importing into the United States. So that's where, that's the infringement side of the house. Let's move on. So we talked about that. Yeah.
Who or what part of the federal government is responsible for dealing with that infringement issue when, knockoffs are made overseas and then brought into the country? Is it you guys or, it's
No, it's not us.
not you guys?
Definitively not us. However, you would have two avenues in that case. If you can get jurisdiction over the foreign company, you can sue them in a U.S. district court. And depending on which district court would depend on where the tort happened and some other things. And, but the other place that you could do that is the International Trade Commission. And what will end up happening with the International Trade Commission, it's like a patent infringement case, but on steroids. So you're gonna do everything, and it's really kind of geared towards the plaintiff, because the plaintiff has the ability to prepare their case before they ever file it. An ITC action really puts a defendant back on their heels. And especially in the case of foreign companies, sometimes they default. We just did a whole presentation at our China IP Roadshow a couple of weeks ago about, how many companies default in the ITC. But all you're going to get out of the International Trade Commission is an exclusion order of some sort, which you can either exclude all the goods that are imported from one company, or you can exclude all the goods that are being imported for everything, right? That matches that description. So those are the two things. You won't get money damages out of the ITC, but if you can stop somebody from importing into the United States, that might be better than money damages. It all depends on what you want to do. But like I said, it is a patent infringement case, but kind of on steroids. And you'll usually get through it somewhere 9 to 12 months, I think is where they're still at. But you can look up their statistics on the International Trade Commission website.
Are you finding that people are using re-exam issue post-grant procedures as a precursor to litigation? They're going to challenge patents.
Okay, so the question is, if you're going to... wait, no, I'm trying to... So first of all, my kid confused me. I'm so sorry about that, but...
Since AIA, there's more avenues to challenge.
Right, okay, so Roger's referencing the post-grant proceedings that came about as a part of the American Invents Act. Those are all handled by the Patent Trial and Appeal Board, and they are very limited, right? It only determines whether the patent should have issued in the first place. It only touches validity. We do not touch whether or not something infringes. That is almost an ancillary question to anything that's a proceeding in front of us. We don't, because those proceedings, so the question was, do we find people who are trying to take out patents proactively, I guess, rather than reactively once they find themselves the target of a particular patent? And there are some.
Defending an infringer, and like the case for infringement seems pretty strong. So it's like, I can't find that, so I'm going to go challenge the patent.
And you can still challenge the validity of the patent in the district court too. It just depends on what you want to do. With the district court, you're not going to get a validity determination for 2 to 3 years.
It's going to be faster, cheaper.
It's way faster with us. So you are 18 months all in and we've had 5,500 petitions that have been filed. We have only missed the date in one out of 5,500. And there was extenuating circumstances. So, but yeah, so it's a determination of validity you get within 18 months. You file your petition at day 1, 6 months later, you have an institution decision, and some aren't instituted at all. And then for those that are instituted, you go through the process, and the Patent Trial and Appeal Board will determine whether or not your patent is valid in view of the prior art that's cited in the petition within 12 months of the institution date. So 18 months all in. It's screaming fast. It's screaming fast. It's an interesting tool. I think when you saw the Patent Trial and Appeal Board start, the invalidity rates or the invalidation rates were really high. Those have actually come down to where they're almost on par with district court litigation. So if you take like a patent through district court litigation and you have a validity case that you do there vis-a-vis the Patent Trial and Appeal Board, they're getting to be about similar now. And I think we're going to see that continue. We're going to see that parity continue. But most of the patents that are in Patent Trial and Appeal Board proceedings are related in some way to patents that are being enforced. There are very few where someone says, I don't like that patent, I'm going to go file a, $250,000 to $300,000 proceeding because I don't like that patent. There aren't a lot of people who have that kind of cash to throw around. So it's usually once the patent has been enforced against someone, then that patent might find itself the subject of a Patent Trial and Appeal Board proceeding. Postgrant. Liam? Zip it. No singing, honey. Anyway. Yes, sir.
You touched on things domestically, but in the event that somebody anywhere else in the world copies your utility patent, begins to sell and market that in other parts of the world, what recourse do you have to trace that down in each individual country?
Yep. So the question was, what if you have a U.S. patent and you, right? You would have to have, you got to chase them down in China. Or in other places where you might have intellectual property. There has to be a one-to-one match between the infringing product, the country, and where you have your intellectual property. Right. Hold on. All right, we talked about that. We talked about a marketing tool. There are still some people who, they say, you really shouldn't sell it if you can't say it has a patent. I'm not one of them. Let's see, so that's the path to the patent. We talked about that a little bit. Provisional application, non-provisional application, and then you go through the process. The process is typically that your application will be picked up by a patent examiner sometime in between 10 months and 16, perhaps 18 months past your non-provisional application filing date. Once it gets picked up, they will issue an office action. Typically, the first office action is a rejection. This is not the excuse for you to go find the tallest building and try and open up those windows and jump out. This is an excuse to have a conversation with the examiner to discuss with them why your invention is different from what the examiner found. I highly recommend it. We have found, and there's a whole bunch of statistics on our website, that if you interview the examiner, you can get the prosecution of the patent more compact, cheaper. It works out well for everybody. I highly recommend that you interview. And you can do your interviews over WebEx, so every single examiner in the U.S. Patent and Trademark Office is set up to be able to interview over WebEx. You get immediate recognition, eye-to-eye contact, that examiner is getting what you're talking about. And you can have a very fulsome discussion over WebEx that really allows you to move prosecution forward. So interview, interview, interview. You can request an interview with any examiner using our AIR form, automated interview request form. That form goes directly to the examiner and it goes directly to their supervisor as well. So if you're not getting a response from an examiner about an interview, you will, if you use the AIR form, you have that documentation to be able to say to their supervisor, I asked him a month ago, right? So do use the automated interview request form. It's on our website. Every regional office has an interview specialist. Every regional office has an interview room that you can use to interview examiners. So if you wanted to interview an examiner, but you didn't want to do it from your home or your workstation, come into the regional office, reserve our interview room, and it works out well.
I have a question for the two patent lawyers here. How often do you guys do that with your clients? Because my patent lawyer has never suggested that I'm involved with talking to the examiner.
I'm probably every other month at least.
Yeah, you're in a lot.
That you'll involve a client?
Yeah, I'll come in with a client and do interviews because it's just more convenient now. Before the Denver Patent Office, it was more of
Oh, yeah.
a deal. We might do phone interviews and
How about the shift work? How often is that?
I don't see you as much, Jeremy.
No, we usually just use
Oh.
online. And maybe in 30% of them.
Yeah.
That.
No, a lot of times, right, when I was in-house counsel for the companies that I used to work for, there were some inventors I'd put in front of an examiner, and then there are others where you're like, no, just no. Yeah.
After you file a provisional?
After you filed a non-provisional application. So a provisional application, all you need to think of, a provisional application is just a placeholder. You're going to get a serial number and a filing date. I am telling you, no one looks at it after that, unless you convert it to a non-provisional, and you must convert your provisional application to a non-provisional application within 1 year of the date of filing, right? But it's completely confidential. No one looks at it. No one examines it. It just sits there. But it helps you win that race. It gives you that filing date so that you can then, when you file your non-provisional application, claim priority back to your provisional. The one caveat to be aware of with your provisional, and this is the way that you want to think about it, your provisional application is the platform for your non-provisional. So you can narrow, but you can't do this, right? Because just like if you were building something and your platform was this and your building was this, that's not a good foundation. So you want to think of your provisional application as the foundation for your non-provisional. Does that make sense? And it behooves you to be a little more fulsome in that disclosure, to give you options when you file your non-provisional application.
Two individuals, one files the provisional before the other one, before B. A files before B. B files the non-provisional before A. A eventually files the non-provisional. A has precedence.
Yeah. If I got that right. I'm not sure I've had enough coffee. Right, if they don't change the content. So actually, the answer should have been, it depends.
Is the provisional kind of like a patent pending? Or is there something different?
Yes, the minute you have an application on file with us, either provisional or non-provisional, you can mark your invention, your marketing materials as patent pending. However, if you abandon your provisional or you don't have any kind of an application associated on the patent side with that invention and that product, stop marking it.
And you could do multiple provisionals.
Oh yeah, you can do multiple. Did you see that case recently though? Oh, that's not good. I'm pretty sure that it's broken, dude. All right, we're gonna have to fix that later. Okay. Okay, we're moving on. Federal trademark registration versus just using something as a common law mark. These are some of the advantages of getting a federal trademark registration. The one that I want to point out to you is that people often overlook, so you can have, associated with one product as we discussed, right, you can have multiple forms of intellectual property. And sometimes the thing that gets you the most bang for your buck and being able to exclude people from the marketplace is actually your federal trademark registration. And so this advantage right here, so for $190 per international class of goods, you can record your registration with U.S. Customs to prevent goods from being imported with your mark on them. $190 per international class of goods. Huh. That's pretty effective. And the interesting thing, so Roger was talking about like the takedown procedures with Amazon, Facebook, Alibaba, actually, even. All of them require that you have a federal trademark registration or that you have the intellectual property in your hand. But the most effective one for them is that federal trademark registration because they will immediately take the products off the website. It's just part and parcel of their takedown procedures. They will not make they have a very hard time, I shouldn't say they will not, they have a very hard time making the determination about whether or not something falls within patent claims. But a trademark, that's pretty much, gut instinct, and they can have a low-level person making those calls. So if you have a federal trademark registration, that is sometimes the single most powerful weapon that you're going to have in terms of getting people out of the marketplace quickly and cheaply, right? Because Amazon, I don't think they even charge a fee. I know Alibaba doesn't, so they don't charge you a fee to take advantage of their takedown sites. Same with eBay.
But if the other product doesn't actually have your registered trademark on it, it doesn't do any good.
Now think about something that it's a kind of a bastardized form of trademarks, but it's trade dress. Right? So if you have a certain look and feel to your product packaging that you can get registered or that you can protect as trade dress, that's also effective.
How about the design patent?
That one's a little bit easier for the companies to make that like eyeball infringement determination, which is what they're looking to make. So that might be effective. Trademarks, though, has been the most effective. Trademark, trade dress. Okay. Oh, by the way, only ever use the circle R if you have a federal trademark registration. Otherwise, it's a TM. So if you ever wondered about that, the TM means it's being used as a common law mark. The circle R means it's a federal registration. See? Giving you life hacks already tonight. The other thing, always use your trademark as an adjective. So something that might have been arbitrary or fanciful can become generic when people start using your trademark as a noun or a verb. So examples of things that became generic: escalator. No. Kleenex actually did a campaign to protect. And the best one, is this connected to the internet? video is just freaking fantastic, because it's like, instead of taking something out of the New York Times, which, how many of us read the ads in the New York Times anymore, right? These guys put it on YouTube. They made it fun, funny. I think they had 2.5 million hits in the first day. Most of those were intellectual property lawyers, and some of us had to watch it more than once. But, right, like, I mean, they really had a massive viral campaign that went along with it. And, you know, now, if anybody tries to challenge Velcro for genericism, they're going to be able to say, look at what we did. We told the public about this. We told 2.5 million viewers of the public that they shouldn't be using Velcro, that it's a hook and loop. See? I can be tough.
To assume if you have a very well-known trademark that your eyes under challenge to genericize because everyone, they want to use it.
Well, it's that,
That on your notoriety.
yeah, it's that sword and the shield, right? Like, if you don't protect it appropriately, it'll end up being the sword that you fall upon. If you protect it appropriately, it's the shield that can protect your products in perpetuity. But basically, yes, once you get to the point, it's a good problem to have. Once you get to the point where you're so famous that people are using your mark as a noun or a verb, you've got a good problem, but you've got to find creative ways to solve that problem and make sure that people know that that's not how they're supposed to be using your mark. I always like to include a little bit of information about our open data. So on our website, if you type in open data, you can get a whole bunch of information and visualizations about states and technologies and other things that are going on. So from 1963 to 2015, Coloradoans filed, or received, I should say, 24,752 patents. They received them in these goods and services mostly. So the top categories of patentees from a technology perspective is surgical instruments, electrical computers, drug and bioaffecting, and error detection, correction, and fault recovery, and multiplex communications. So, and if you know, like, the corporate history of Colorado, it's really interesting to watch because, oh wait, hold on. This one right here, dynamic magnetic information storage or retrieval, from 63 to 2015, that's actually the top category of patenting. So what company was here? Yeah. All right. Surgery is now the top one. Who's here? Thank you. There's so much you can tell with the data that the U.S. Patent and Trademark Office makes accessible, and it is all open. You can download, like, bulk information, slice it, dice it, do whatever you want with it. If you do find something really interesting from a visualization perspective, please do let us know about it. You can put it back up on our website, or you can tell me about it so that we can use it. We did something with NIH and a couple other agencies, and we called it the Cancer Moonshot Challenge, but basically we were able to plot the rate of patenting with the number of research dollars vis-a-vis survivability of various cancers. And we've done that on a couple other things too. I mean, we did that with green technology under the Bush administration. We've done it, you know, in various areas, but it's kind of interesting, and I love the fact that we're making this data open so that people can just look at it and see what's going on. Because you can tell so much about a state or so much about a certain area of technology by where people are patenting. All right, so there's that. We talked about this. The two other things that, that happened with the America Invents Act, and we're actually really proud of this number two. So we received the ability to set our own fees, and they have changed since 2011, and they're hopefully going to change again. But because we had our own fee-setting authority, we were able to hire more patent examiners. So we reduced our patent application backlog by 30% from its high in 2009. And that's despite a 4% year-over-year increase in filing. So because we were able to set our own fees, we were able to put patents in the hands of inventors and entrepreneurs faster. So the other thing that we did was this Track 1 patent examination. We tried a bunch of different ways of accelerating patent examination, including, like, you know, we'll accelerate one patent if you give up 2 applications or whatever. We tried a whole bunch of things. They didn't work. What we have found that works is this Track 1, and it's just a payment of a fee. So for large entities, it's $4,000. For small entities, it's $2,000. And for micro entities, it's $1,000. And you jump to the head of the line. So we limit it to 10,000 applications per year. You file your track 1 petition. We take about 2 months to grant the petition. 98% of them are granted, kind of a given. And then from your petition grant date, we guarantee that you'll have a final disposition on your patent application in 12 months. We've actually been averaging 6.5. So.
Accelerated exam doesn't exist anymore.
No, it does. Oh, yeah. Track 1 is still there. It's just 10,000 applications. So once we reach 10,000, and actually,
That was something that was started, I think, before track 1, where you,
oh, that 1 for 2, or, yeah. That one is gone. That program is gone because nobody used it.
That's still around. Accelerate is still around, where you have to do a search and submit.
Oh,
it's like a.
You don't have to do the 2,000 or the 4,000.
oh, but that's accelerated examination. Yeah, that's still around. The 1 for 2, where you would get 1 application fast-tracked if you gave up 2 of your applications, that's no longer around. That one isn't there, but accelerated examination is.
I have a prosecutorial question for you. So the 10,000 limit, I think this was the first year where, I don't know if it got hit, but it was getting really close.
Mm-hmm.
Or in September.
Mm-hmm.
So if you submit a track 1 and you're like number 10,001, do you get the option of delaying it to October 1st? Or does it just go through as a normal application? Do you know?
We didn't refuse anybody. And
So it went over?
no, it didn't go over. We just granted the petition, and it was just 10,001. Whatever the number is that we reported. I think fiscal year 2017, which is the one that just finished, that's the only time that we've actually reached that limitation. And I actually think our Patent Public Advisory Committee is recommending that we increase that to 15 or 20,000. 10,000 was just a number. There's no statutory, there's no scientific basis for why 10,000 was there, and it's totally within our control to increase that. So we did not deny 10,001, and I don't think there's an appetite at the office to deny even 10,500. Because again, going back to the beginning, right, we know it matters when we get the patents into the hands of entrepreneurs, startups. Right? It makes a real difference. So we want to make sure that happens.
I just want to say, I think the micro and small fees are fantastic.
Okay.
For my startup,
Yeah.
it was a non-starter if I had used the standard.
Thank you. Thank you for that.
So it was a huge difference.
So now small was always in existence, or at least has been since I was a baby patent attorney, which is much longer than I care to admit to anybody. But right, the micro entity came about as a result of the America Invents Act. And so
And I know many
we love it.
other folks that I'm associated with that. It was a non-starter, even small. It
Right.
was doable for many people. Because
Yeah.
of the legal fees,
Right.
we still dwarf those, but
Uh-huh.
when you add those 2 together, it's a non-starter for many people. So if you can
Right.
keep those micro ones as small as you can.
Well, so the other thing that we did, recognizing, of course, that our fees are kind of that drop in the bucket as compared to paying the patent attorney to write and prosecute your application, the Patent Pro Bono program is in all 50 states, and this is where under-resourced inventors and startups can get patent attorney help for free. Under-resourced, I think, is relatively generous because I think it's 3x median income. So I think for Colorado, that means if you make less than $170,000, you're under-resourced, which is great because that means I'm under-resourced. So, it's one of those things. We've found amazing success with this program, not just... You basically call up, so in Colorado, it's ProboPat. You call up Jennifer Rothschild at Mikasa Resource Center. She does kind of a gut check to make sure that you have a real invention, and then you have to submit your tax returns. so that she knows how much you made, and then she matches you with a patent attorney. And it goes from there. You design the relationship you want to have with the patent attorney. Some will say, I'm only going to do searching for you. Some will say, I'm only going to write your application and you're on your own after that. And others will say, I'm going to take you all the way through the process. There's a couple really neat success stories, though. So the one that's from here in Colorado, Deborah Campbell, she came through the patent pro bono program, and she was like that perfect. She cobbled together all the different government resources. We had no idea she was doing it this way, but it worked out pretty perfectly because she's given a success story to SBA, SBDC, the incubator out in Grand Junction, and us. So, you know, she cobbled together a loan from SBA through, I think, SBIR. And then she used SBDC for some of her business plan and business development. She went through Mikasa for the patent pro bono program. And then she used Incubator out in Grand Junction to do all the prototyping for her 2-minute sushi maker. And then started up her business. She's having it manufactured in China. It's supposed to be on Amazon soon. And, you know, she's a mom who got frustrated because sushi is really crappy to make by yourself. And she wanted a better way to do it. So she and her family came up with the 2-minute sushi maker. And, you know, now she's got a business. It's kind of cool. So that's one of the things that we also innovated because we recognized that access to the intellectual property system is precluded for a lot of people, right? And we really do. We want those dreams to turn into reality because we recognize the fact that small businesses are the only people really creating jobs in America, and we need you to do it. So that's one of the reasons why we do that. 5th anniversary, we already talked about this. The Defend Trade Secrets Act, this one I personally like. I am very excited about this, and I think over the last year since it was enacted, it's proven to be kind of interesting. Trade secret was always a creature of state law, so 50 different definitions of trade secret, 50 different definitions of misappropriation. With the Defend Trade Secrets Act, Congress, and you had to file in state court. So I always like to tell the first trade secret case I ever had as a baby attorney. The company was in New York. The company that he took the trade secret to was in Ohio, and he lived in Pennsylvania. So where do you file that trade secret misappropriation action? Do you file it? We filed it in all 3 states. And I had 3 trade secret actions going on at once. It was a train wreck. I mean, I was so lost. I would have killed for something like this because the Defend Trade Secrets Act gives you one definition of what a trade secret is, one definition of what it means to misappropriate a trade secret, and it puts it into federal court. So
Does this preempt the state action?
it does not preempt the state action, so you can still file in state. You can do them in parallel too. Okay. 2 other places where we have been pretty active lately in protecting our stakeholders. This one is actually really cool. So once you get into the trademark system and you're a trademark owner, you will receive a whole bunch of notices that say, we're, you know, such and such company, pay us your USPTO fees and we'll make sure that we pay and you don't have to worry about it. And they'll send you invoices that look like they come from the U.S. Patent and Trademark Office. So I will tell you right here, right now, the U.S. Patent and Trademark Office will never send you an invoice for a fee. If you get an invoice for a fee, I guarantee you it's not coming from us. If you get an invoice from your attorneys, that's one thing. That's not coming from us. But if it has the USPTO symbol on it and someone is trying to tell you that you're being invoiced by us, it's bull. So don't fall for it. If you get one of those, look at who the company is, go to our website. We are naming and shaming. We are, you know, as soon as we find out one of these private companies that are actually defrauding our stakeholders, we put them on the website. And then we worked with the California Attorney General to, prosecute 3 guys in California who had defrauded our trademark applicants to the tune of $1.66 million over the course of the years, and we got them on federal money laundering, fraud, and perpetrating a trademark scam. So Don't fall for it. If you even have a question about it, like you get something and the company isn't on our website, call us up, let us know. We'll make sure that it gets there, because you guys shouldn't be getting ripped off. When you're investing in your dreams, you shouldn't be getting ripped off in the process. This was also something that we did. We worked with the FTC recently, and in August 2017, we received a preliminary injunction and seizure of assets for this guy. Scott Cooper, DASA Industries, or World Patent Marketing, would basically say, give me your invention and I will license it and market it for you. And he did nothing, right? Like, he would send people this congratulatory language about and valuations, free applications that never got filed. The guy was absolutely a used car salesman, shyster. It's awful. And the worst part is that it was a lot of money. It was, I want to say it was over $20 million in 4 years from people. So please, 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 this is where I tell you, if you're an insomniac like me and you're watching those late night shows, don't call that number. Do your research, and if the company that says that they're going to market your patent, your invention for you, doesn't give you the name of a patent attorney that you can go on our website and check out, every single attorney who is authorized to practice before our office is listed on our website. So if you don't have a real name that you can go check on our website to determine whether or not they are actually registered to practice before the Patent and Trademark Office, be very careful. Be very wary there. And even then, right, do your due diligence on your patent attorneys and your intellectual property attorneys, because they're going to be protecting, I'm sorry, but right, like they're going to be protecting the most important assets your company is ever going to have. So you need to do your due diligence on them. Look them up on our website. Go to the states where they're registered as attorneys. You can look up whether or not they've been disciplined for anything. Feel free to try it out on me, Kocialski, Kocialski. You can go to the state of Colorado website and look me up, right? Seriously, do your due diligence on them. And then for most patent attorneys, they will have like a website. I know you have one, right? Like where it'll talk about their background. So, you know, if you happen to be in some medical diagnostic field, you don't want to hire the software engineer to write your patent application, because then you're paying to educate them about something that they aren't familiar with. So please do your due diligence, find the attorney that's going to work for you. Perhaps avoid the companies that are out there to take your money and not give you anything for it. We talked about track 1 already. Independent microentity status, we talked about that. That's that. Let's see, higher ed microentity status. Also that. First action interview pilot, these are some of the statistics for that. We really do like this program as well, if you can participate in it. Pro se assistance program, this is one of the other new inventions. So out of that 650,000 patent applications that were filed, about 3% are filed by people who are representing themselves, or pro se. In Latin, it means for yourself, right? So for the people who are representing themselves, they often are not patent attorneys, and they need a little bit of extra assistance. And what we found was when we assigned pro se applicants to examiners just in the normal course of business, it didn't go so well. And both the pro se applicant and the examiner had really horrible experiences, right? So what we did was we said, okay, we want to make sure people who are representing themselves have that extra assistance. So we can't write things for you. We can't give you advice. We can give you information. And we formed a pro se art unit. And in fact, I think Denver is the only regional office that has a pro se art unit examiner in it. But we formed this unit that is dedicated to helping people who are representing themselves in front of the office. Now, only about half of that 3% goes to this art unit, but there is talk about, you know, do we expand this to cover all of the pro se? Because since we formed that pro se art unit, our stakeholders who are representing themselves, their approval process, you know, their approval rating of us has gone through the roof. We find that they get through the process easier, And because we've given the examiners who are in this unit more time and extra training in how to work with the inventor, they have higher levels of job satisfaction. In fact, every single one of the examiners that are in that art unit were originally assigned on a detail assignment, and we call a detail anywhere from 120 days to a year. Every last one of them has asked to extend because they enjoy the process so much more. Again, they have extra time, they have extra training, it's working out really well. If you have been a part of the Pro Se Art Unit and you have experience with that, please do write us a note to say, if you liked it, please do write us a note, or even if you had a pain point with it, let us know. PTRC, we talked about that. We talked about, law school clinic program. I like this. This is a win-win in my book. It gets students practical applications for them to work on, practical skills in terms of handling clients. The only law school clinic program that we have is at the University of Colorado right now. I have every intention of changing that soon. So, but it's patents and it's Colorado only. I'm hoping we will have a trademark law clinic coming online soon. But that's where you take your work to a student. They get the hands-on experience, you get free assistance. The students are supervised by a registered patent attorney or an intellectual property attorney. So it's not like you're getting, the kid who's operating on you the first time. I mean, yes, you are, but he's got someone right behind him that's guiding that scalpel. So anyway, there's that. Told you about finding a patent practitioner. You can do that on our website. Jeremy, did you have a question or a point?
No, I was just going to make sure you pointed out that there was an attorney supervising.
Oh, no, yes. Yeah, no, we don't let them do it. But interestingly enough, right, the students, at least on the patent side, actually get a registration number. It's a provisional registration number, and they're allowed to use it as long as they're associated with the clinic. But it's also something that they can put on their resumes. So anyway, or we also have externs at the U.S. Patent and Trademark Office. We're the only regional office that has externs year-round. So if you know budding law students or engineers who might want to find out what patent examination is all about, send them my way. They work for free, but they get really good experience. Patent Ombudsman, this is if your application gets stalled somewhere, it helps get you back on track. Please do call the Patent Ombudsman if you're having issues. You can also think of your regional office as your Patent Ombudsman if you're having problems. If you have a pain point, come talk to us. We want to hear from you. I can say this. The U.S. Patent and Trademark Office of today is not the one that when I started as a baby patent attorney so many years ago. There is a real commitment to engaging with our stakeholders. There is an insane commitment to transparency and a real commitment to improving the process where necessary. Just 2 weeks ago, Commissioner Hirschfeld said about one of the programs, he's like, it makes everything better. If our stakeholders understand what we're doing and why we're doing it, it makes the entire process better for everybody. And so he's very committed to that, and I'm very pleased about that as well. All of our inventor and entrepreneurs resources are in one place. So the awareness assessment is on this page. The Trademark Assistance Center is on this page. The Inventors Assistance Center is on this page. There's a whole bunch of stuff that's on this page. So, there's the awareness assessment right there. And then that's uspto.gov inventors. And that's it. Any other questions? I threw a lot of information at all of you, so if you feel like you just drank from the fire hose, I apologize. But thank you, Gary, for taking notes. I really appreciate that. That's awesome. Any questions?
As a pro se, I know way back when I started it, the examiner was required to write at least one claim for pro se. Do they still do that?
I don't honestly know. That would be a question for Josh. I'll ask him and get back to you. Yeah. I don't know what I know that they get the extra training. I know they get the extra time per application. But I don't know if they're required to write a claim still. And so much has changed, remember? Because when I had to write a claim when I took my patent bar registration. I know, that dates me, right? And you don't have to do that anymore. fact, they stopped doing that the year after I passed. So, you know, not that I'm bitter much. But yeah, so there's a lot of that that has changed. I actually don't know the requirements, but I'll ask. Yeah. I love the program. I'm very hopeful that they'll expand the unit to cover all of the pro se applications that get filed with the office. I don't know that that'll happen. A lot of that is going to depend on time, budget, resources. Yeah. Exactly. Exactly. Although, right, like I always tell people, your first office action rejection, not the excuse to throw yourself out of that 14-story window. You know, it's just an invitation to explain to the examiner why you're different. Think about it that way and be prepared to have that conversation. But that's also one of the reasons why we think a best practice is to do your searching. Because then when you do your searching with us, you're using the exact same databases that the examiners are using, so presumably you're coming up with a lot of the same art. And then you already have, instead of, you know, having to figure out how you're different once you receive that first office action, if you've done your search appropriately, you'll already have your arguments in hand. So it becomes a little less intimidating at that 3-month mark. So, I know. Any other questions? As always, feel free to call us, come visit us. Just don't bring anything that you wouldn't take through the airport, please. But no, come visit us, come see us. We love visitors. We'll take you on a tour of the office. We'll do, yeah. My son is actually testifying about that yes, we do love visitors. So please, use our search rooms, use the interview room. Come see us, ask us questions. That's why we're here. And that's the beauty of having us in your backyard. Yeah. Thank you.